Thank you for giving me this opportunity. I think it is fascinating to hear. I'm neither a politician, I'm neither a RTI activist, but yes, the term RTI, let's just go back in time, in say 1998, when still writ petitions were called and termed and styled as writ petitions, whether they were public interest or otherwise, you actually had citizens who filed and lawyers making an application, and the first application was the court may please be direct the necessary statutory authority to part with this information. I think that was the first prayer that you would actually make. Then, of course, in 2000, etc., when the term PIL, and now we have public interest litigation number so and so, the whole thing changed. I think we should just go back to the Act itself. What does the Act really say? It says if you have the information, please give it. I think a lot of what we heard today was, I don't want to, this ex-government doesn't want to give it, or this statutory authority doesn't want to give it. Unless you fall within the exception of the rule, you have to give the information. And I'll give you a very good example where they've actually given it. The 26/11, when it happened, a colleague of mine, we had actually filed a petition asking that how is it possible, or is there a committee that the Defense Ministry has to look into, very accurate, because they had very detailed maps. Where did you get all this from? And is the government doing something for it? Now, it actually looked as if this particular lawyer had prior information and he filed this prior to 26/11 happening. I actually had the Chief Justice asking me this question in court. I said no. And in fact, although it was a defense subject, the Defense Ministry, the Union of India, came and said, no, we are doing something about it. Contrast this with Pune Lohegaon Airport. A person who was an RTI, the owner of that property prior in time, says, I want information to know how many hectares or how many bighas land belongs to the Air Force and how much belongs to me. And the court says, no, nothing doing, you cannot have it. I would certainly, I'd like to look into the Girish case a little more, in the sense that, was notice issued, was the petition actually admitted, and then a detailed order passed, and therefore it is being utilized as a precedent or not. The other thing you must remember, the way our Honorable Supreme Court is going today. Okay, please remember there are benches which pass contrary orders every day. One bench says this, the second bench says that. It's fine. This is part of the system, and you should be able to go back to the court, perhaps come back to the Bombay High Court, ask for a larger bench, say that this issue has not been decided in a given case. I have my friend Samir Zaveri here. We're talking about 2008, PIL 50 or 2008. Every time we go to court is thanks to an RTI application, because the railways have not done this. This particular officer has not taken this forward. And so I think the question is, you can certainly look at all these issues. They are open to judicial review. Let's not be fixed with the idea that the law is constantly changing, and I think that is important. We must remember it, and we must go back to the court. We certainly talk to people about it, express yourself, but certainly it's not the end of it all. One judgment passed in, for example, do you remember what in say 1940 Rangoon judgment, what the court said? Certainly not. So go back to the institution, say times have changed. Yes, they don't like to admit that they made a mistake, but that is human fallacy. It happens, and in a given case, maybe you can set the Girish Deshpande judgment aside. It doesn't have to be the law. The other important thing that you actually spoke about, and I think is we are on the brink of a very interesting side. a certain senior advocate has filed a petition asking for direct and live streaming of Supreme Court proceedings. We've intervened saying that that's not good enough. We need now legal transcription. I think this one single act, and very interestingly, and unfortunately, the Attorney General's statement in court again has not been recorded because we don't have transcription. 90% of our citizens don't realize that that poor so-called steno sitting there, he's not writing everything that is happening in court. He's only writing what he's told to write. Now, when we go and watch, proceedings in other countries, since the, I think, 40, 50 years, the US has it, other countries have it. Why not here? I think a lot of the systems that are in place today will change because one important thing is people will, sit on time, things will happen, people won't shout in courts, the media will report things exactly as they are. So we are really hoping this happens. The other important aspect is, think about from the disabled person's perspective. When he goes into court for his own issue, it's, he says, listen, I mean, we've had disabled clients who come and said, all this is fine, but what exactly went on? I mean, jocularly you can say, well, you know what, just think that you've attended a circus and come back home. But the time has come, under our right to persons with disabilities, it is now mandatory. I think it's amazing to have every single thing in the sense not only being recorded, but in in an area in a sort of the recording of the disabled person's opinion and his argument should be exactly in a language or in a substance that they understand. Like, for example, for a braille for a blind person, legal transcription certainly, again, for a person who cannot hear. So I think we're going to see these changes, and all this will have an effect, certainly. So as far as the right to information is concerned, yes, I think you must ask for it, continue to ask for it. And the other aspect is on the implementation. Now, if certain information is there, and the person, say the government files an affidavit giving the information. Now, if that information is found to be wrong, the implementation of that, unfortunately the Central Information Commission doesn't have the powers to, set us aside. I think the courts have the powers to do so, saying that despite you giving the information under the right to information, how can you give wrong information based on which certain decisions have been taken? I mean, there are a lot of people in this room whose petitions are pending in the High Court and Supreme Court based on this aspect, non-implementation based on the right to information. I think this is another very, very serious area that needs to be looked into.